Welcome back to Gray Matters, the podcast of the C. Boyd and Gray Center for the Study of the Administrative State. I'm Jace, Lington, the Center's Research Director. If you're listening to this podcast, by now you've likely heard the news that Judge Aileen Cannon dismissed the case brought against former President Trump related to how he handled classified documents. She made her decision based on the argument that Special Counsel Jack Smith was appointed to lead this prosecution in an unconstitutional way. I can think of no one better to invite to discuss this topic with us than Jennifer Mascott. Many of you know that Jen was until recently the co-executive director of the Gray Center. Now she's the director of the Separation of Powers Institute at the Catholic University of America's Columbus School of Law. She also founded the Constitutional Renewal Foundation to bring attention to issues like this one. We're grateful for the time we got to work together, and we're happy that we remain friends. Given her expertise in this area of the law and her experience working in the Department of Justice, we're grateful that she's joined us today to share her insights into the case. Welcome back to Gray Matters, Jen.
Well, thanks so much for having me, Jace. It was great to work with you and Adam for a few years there at the Gray Center. And Adam and I, through the Gray Center and the Constitutional Renewal Foundation, just hosted an event last week looking at financial regulatory matters and some of the implications from the court's most recent administrative law decisions, including Jarkissi versus the SEC, which raises issues of due process and jury trial rights in the context of agency adjudication. And it's exciting to be with you today to talk about what's happening now, also related to the power of the executive branch, but in the separate area of the special counsel and relevant statutory issues. And perhaps surprisingly, Judge Cannon's decision today raises some interesting questions related to the appointments clause that don't as frequently come up in the area of the appointments clause, and perhaps in light of Justice Thomas's concurring opinion in the very closely watched and studied presidential immunity decision from several weeks ago, perhaps are going to shed light on some additional aspects of the appointments clause that have not come up as much in the past in decisions by the Supreme Court or judicial decisions as perhaps some other aspects of the appointments clause. And it might even be helpful just to give our listeners a bit of a just basic primer on what we're talking about when we say the appointments clause, why it's relevant, and why it's starting to make cameo appearances in these cases involving the special counsel and involving presidential immunity.
Yeah, so if you wouldn't mind, for listeners who maybe haven't had a chance to read the 93-page order or who haven't been following the details of the case, what did Judge Canon decide this morning?
Sure. Well, first, if I just back up and talk about the appointments clause, I mean, essentially, she dismissed the indictment against President Trump, and on the ground that the indictment was brought by the special counsel Jack Smith, who, in her view, and she raises two constitutional grounds that she sort of says are interrelated, and we could talk about that a little bit more as the podcast goes on. But essentially, she said that there is no statute properly creating the office of special counsel, and that in her understanding of the appointments clause, that means that the office of special counsel does not constitutionally exist. It wasn't set up properly by congressional statute enacted into law, and that's a constitutional violation. If we can just back, so the posture of this case is that essentially this means the indictment's dismissed. It's almost certainly the case strategically, I would think, that the Office of Special Counsel will appeal this to the 11th Circuit U.S. Court of Appeals. And so the U.S. Court of Appeals would then have a chance to reverse or affirm Judge Cannon's decision. Based on what they do, then perhaps the case will come up to the Supreme Court, which then would take a look at it. And just thinking about, is this unusual? Is this strange? Well, if we think about another case that the court had recently, the January 6 indictments, and whether the January 6 indictments were brought properly under relevant statutes dealing with obstruction of justice charges. Interestingly, in that case, the district judge in the D.C. District Court, Judge Carl Nichols, had thought that the statutes hadn't been properly read and didn't actually support the full scope of the indictments and were being misread. He was reversed by the U.S. Court of Appeals for the D.C. Circuit. And then the Supreme Court came in and a little bit earlier in June essentially agreed with the bottom line of the district court. So here we have another situation where we've got a district judge, although this time coming out of Florida, Judge Canon. And of course, she's had more relevant decisions that people are paying closer attention to because she's been overseeing the much more publicly salient and tracked prosecution of former President Donald Trump for the documents cases in Mar-a-Lago in Florida. So folks have been paying close attention to this litigation for quite some time. But here again, we have a district court judge issuing what some might think of. It's certainly an impactful decision. Whether it's surprising or not, it's impactful. And it's almost certainly going to go up to the 11th Circuit. And then, we would see even if they affirm or reverse, of course, the Supreme Court sometimes circles back and agrees with the district court judge. What's interesting here, and I can pause to see if you've got follow-up questions, but that's the posture of the case. Then it probably makes sense to explain to listeners, how on earth we're talking about the appointments clause when we've got this position of the special counsel. Haven't we had special counsels for many years? We had special counsel Rob Hur dealing with, President Biden and issues of his recollection and the publication of that report. We've got these separate Jack Smith cases. There were a number of special counsels, including Robert Mueller during the Trump administration, special counsels going back a few years before then. If they've been around for quite some time, why are we all of a sudden talking about constitutional issues related to special counsels? Is this just really unusual, or is there something more going on here?
That's a question I had. So let's stick along those lines. You said that this case involved factual questions about whether there was statutory authorization for the appointment. What makes Jack Smith different from some of those other special counsels you mentioned?
So Jack Smith actually, so the special counsel statute or potential statutes or regulations within the Department of Justice are the same for most of these special counsel cases. So it is the case that there's precedent over the past few years in terms of practice. The executive branch has been relying on general statutes and then regulations within the Department of Justice to authorize and for the AG to appoint special counsels now in multiple occasions. And so there is a past practice of it. The special counsel statute's a little bit newer than some of the other statutes creating and structuring the Department of Justice, or at least used in a little bit new fashion, in part because it used to be that sometimes the independent counsel statute was used for investigation. So that, for example, think Ken Starr, think President Clinton, think impeachment. Why do we no longer rely on the independent counsel statute? That was an office that was even more independent, not structurally, not hierarchically within the Department of Justice, like the special counsel. Well, Congress actually let that statute lapse. So there isn't really a statutory authority clearly anymore for independent counsels. So instead, we have the special counsel structure, and we can get into the specifics of whether a statute authorizes it. In Judge Cannon's view, no. She's saying that the Department of Justice has been relying on statutes that are too general. They don't give specific enough authority to create the special counsel provision. And also because she thinks they don't give clear enough authority to create the special counsel provision, she says there's a second constitutional problem or statute, which is that there's not a clear enough statute authorizing appropriations and funding for Jack Smith, because the appropriation statute that's being used makes a reference to authorizing expenditures that are supported by law. And so if there's no clear law creating the special counsel office, then she's saying similarly, there's not really a law on which to find the hook for the appropriations authority. So we can get more to the appropriations argument in a minute. The court heard an appropriations clause. The Supreme Court challenged the Consumer Financial Protection Bureau earlier this term and rejected it 7-2. Judge Cannon's decision here is making a somewhat distinct appropriations clause claim. So whether the court will take a totally fresh look at that if the issue comes to it, or what the 11th Circuit will think it's bound to do in light of the Supreme Court's opinion, is unclear. It doesn't have direct authority on point. She's making a separate argument. So we'll see if they see the appropriations clause arguments in a different way, if they ever get that ground for the decision this term. But she has a more direct route to find constitutional problems here that she spends more of her opinion on, and that's this appointments clause argument. And so maybe for the listeners, the appointments clause sounds kind of like maybe a perhaps boring or esoteric lawyer or litigator or law professor clause. Probably that's true, but obviously the public is quite aware in general of how the appointments clause works, because the appointments clause is the reason, for example, that we have contentious or closely watched confirmation hearings for Supreme Court justices, for significant cabinet officials like former AG Barr or others who are heading up departments now in the Biden administration. And so it's a core constitutional provision that the public does see played out on a fairly regular basis anytime there's a vacancy in the judiciary, or anytime we have a new president trying to fill his or her administration. So what does it basically say? It essentially says that the president shall nominate, and by and with the advice and the consent of the Senate, shall appoint ambassadors, etc., judges of the Supreme Court, and all other officers of the United States whose appointments are not herein otherwise provided for. So that's the main part of the clause that essentially gives the Senate a role in the confirmation or approval of the people that the president is picking to fill offices of the United States. What's interesting is that there are a couple of other parts to the appointments clause that we don't necessarily focus on as much. So after, for example, that provision requiring Senate consent, generally speaking, for officers of the United States, the founders gave sort of a backdoor so that the process of government wouldn't be slowed down by every office having to be filled just with Senate consent in case there was a logjam. So it says in the cases of inferior officers of the United States, Congress can by law provide for those individuals' appointment by either the president alone, a head of a department, so think cabinet secretary, or like the commissioners of the Securities Exchange Commission, or a court of law, as Congress thinks appropriate. So this part of the appointments clause for lawyers is also fairly well understood, and the Supreme Court occasionally gets cases dealing with this question about exactly who's an officer of the United States. Is everybody who works for the federal government? Well, the Supreme Court has said at least people who have significant authority. It hasn't really applied the clause to that many people, but when it does, it's looking for several issues. Is the person a principal officer and a non-inferior officer, a superior officer who has to be appointed with Senate consent, or can Congress establish the person's appointment in a different way as an inferior officer? So a lot of the arguments in the past, in this case, in general, dealing with the special counsel in prior cases, even with some of the amicus or amici or friends of the court arguing in the Judge Canon litigation, we're looking at this principal versus inferior officer line and saying Jack Smith seems to have a lot of authority. The Justice Department doesn't seem to be claiming close supervision of him. In fact, the Attorney General is trying to distance himself and saying he's independent. So he looks kind of superior, like he's not inferior to the AG. He doesn't really have a supervisor. Judge Canon did not really want to decide that issue. I think she said, understandably, or at least, based on the lack of historical work, and also I think some of the inconsistencies perhaps in the way that the arguments are coming up in this case, right? Because the special counsel is inferior in the sense that he's nested within the Department of Justice. However, he's operating outside of the normal level of supervision that like a rank and file appointed official or employee, such as the spots I might have held previously as a deputy assistant attorney general would have had in the Justice Department. So Judge Canon intriguingly said, you know what? I don't really even have to decide that here because there's an even bigger, more threshold, more fundamental problem with this special counsel provision. And that is that it has not been established by law in the first place. And so what's interesting, and I personally find like deliciously fascinating here, in part because of my background in scholarship and Justice Thomas' separate writing, the presidential immunity decision, and also because, as I'll explain, I think this is actually perhaps the key aspect of the Appointments Clause, even more important for accountability and for government and for structure and for freedom than the Senate consent provision that comes up in the nomination of justices and cabinet officials. The Appointments Clause very clearly refers to offices of the United States being established by law. The term law appears multiple times in the Constitution. It essentially is referring to statutes. It's referring to law that the founders found very important, had to go through what we call bicameral presentment. If you think back to your grade school days, how a bill becomes a law, the first article of the Constitution giving Congress power, vesting legislative power in them, says how a bill becomes a law is it has to pass the House of Representatives, has to pass the Senate. We think those bodies are created in really important ways that can't be altered by the election of folks. And we've got to have 2 senators for state. House of Representatives is more by population. And there were many, many fundamental, important compromises and agreements struck and developed in setting up that bicameral body. That's been really integral and key to the continuation and flourishing of our country and our liberty over the past more than 200 years. And then also the president gets to sign or veto and must sign it. Or if he vetoes it, then it can only be overridden and become law by 2/3 vote of both chambers. So it's very, very challenging, as we know, to get a law passed. And the Appointments Clause essentially indicates that there's not going to be any office other than those that are referenced explicitly in the constitutional text. So we know we're going to have Supreme Court justices. We know we're going to have a president and vice president. There's a reference to a speaker of the House and like the congressional leadership. But what's interesting, we don't think about it a lot, is that even though we have a vast, vast executive branch set of administrative agencies right now, today in 2024, not a single one of them was specified and required to exist by the text of the Constitution itself. The first Congress established 3 departments plus the Attorney General. Now, of course, we have many, 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 and agencies. There were some also smaller commissions back then, and other officers like customs officials and things. So there was actually a relatively robust set of executive officers in the original, established by the original Congress back in 1789, 90, and 91. They were established by statute. If you go through and read, as I have, it makes me seem even more nerdy to admit, but made a spreadsheet of and studied and read all of those initial statutes, figuring out how the initial government was structured back a few years ago for an article on the concept of officers in the United States and the Appointments Clause that was published in the Stanford Law Review. There were provisions establishing these offices. So Judge Canon is essentially saying this was agreeing. This was a key constitutional requirement. This is a threshold requirement. And essentially, I don't see the clear statute here establishing special counsels generally. So, great that the Attorney General and the Department of Justice has regulations telling us how these investigations are going to play out. But I don't see the clear statutory text establishing this by law in the first place. This was a bit of a focus in some of the arguments before her. But I think what also really brought it to light is that, interestingly, Justice Thomas wrote separately in the presidential immunity decision handed down at the end of June, saying, by the way, I think separate and apart from the whole issue of immunity and official act in the first place, I'm concerned about the constitutional grounding of this investigation because I see a problem with this creation of the special counsel by unclear statute. And it's not clear to me that there's a law establishing the office here. And the litigators in the case, President Trump's lawyers in the Florida litigation, actually filed what we call a supplemental motion, bringing attention to Justice Thomas as one of the 9, raising questions about this very question of constitutional law, and raised that to Judge Cannon's attention. And so she had that motion and Justice Thomas's concurring opinion and all of the earlier arguments before her when she dismissed this case. So I guess I should pause there and see if you have follow-up questions. And then I thought I would turn to what's interesting about Justice Thomas's concurring opinion is in it, he goes through and he explains the significance of it and why we should care about something that might seem kind of superficial and technical. Who cares if it's a statute or a regulation establishing special counsel? How clear does it have to be? Why is this a grand issue of constitutional law? And he frames that for us a little bit in his concurring opinion in Trump versus United States. But first, any comments or pushback or questions about the earlier discussion?
Yeah, thank you. I definitely want to get into his concurring opinion, but I guess just procedurally, has the DOJ made a claim that this might be even a delegation issue? Has Congress given them any kind of leeway to make these decisions, or are they just making regulations hoping that it'll be okay?
Well, so on that point, what's a little bit tricky is that, of course, we have a vast executive branch. And so it is the case, even for hundreds of years, that Congress, when it creates offices by law, will sometimes do it very specifically. Like it might say there's to be an attorney general and he or she will do X, and then there's a deputy, and then there's an associate, and then there can be 9 assistant attorneys general. But it might leave details to be filled in. So, for example, with the Department of Justice, actually by statute, it doesn't specify what subject matters these assistant attorneys general have to cover. The Justice Department has flexibility. Sometimes early on, like 1789, Congress said to, for example, the Treasury Secretary, you can establish and appoint as many clerks as you find necessary. So here, there are relevant statutes with relevant text talking about establishing different aspects of the Justice Department and the establishment of different investigations. And so really the question is, if you look at the context of the statutory scheme, are those statutes specific enough or on point enough to authorize this type of special counsel? Or is the government relying on general statutory language or unrelated statutory language that doesn't really make its way across the threshold? So, of course, they have an argument of statutory provisions they think are relevant. And Judge Canon saying that's not actually good enough. And I think that one of the reasons why she, or at least why Justice Thomas, highlighted questions of it is because, number one, of the significance of the power that the special counsel's operating and exercising, which everybody's talked and heard a lot about in the presidential immunity context, but also because of the significance of the constitutional constraint and requirement that offices be established by law. So if we just step back, for our listeners or for students who might be listening or lawyers or folks who find these things interesting, or even people who value our American system of government and freedom and accountability and don't just want 1 or 2 powerful people making all the important decisions for us. Why did the framers establish things this way? Well, look, obviously we all know we came out of, rebelled against, declared independence from the British system of government. What did the monarchy look like? What were some of the abuses we were concerned about in the Declaration of Independence? Well, one of them, there's a reference in the Declaration of Independence, the king sending swarms of officers to oppress us. And the problem is that at various points in time, the British practice, the king had a lot of authority to, in exercising and carrying out his role and his power, create positions and fill the position. So if you think about how much power that gives, right? If one has access to a certain amount of funds or a certain amount of authority, if you can just you can say, declare, I need somebody to help me exercise this power, and here's who it's going to be. That was along with all of the other things we hear about a lot, right? With taxation and Boston Tea Party and all of the things that are front and center of our history books in grade school. An additional problem was the king having this power to just create new positions and fill them with people. So the Constitution addresses this in Article 2, giving power to the president by actually taking away some of that executive power. So some people think, and some of my scholarship talks about this, that the power to the vesting of the executive power in the president, if that were all the Constitution said, if that were based on monarchical practice, that might have included power for the president to say, oh, I need people to help gather taxes, to help count the money, to help carry out the statutory power that Congress has given me and fill the offices. And the Constitution essentially said, no, we want to take away that historic understanding of executive power, and we want to break it up and divide it up. And there's not going to be any office under the president and vice president unless it goes through the statutory process of law that's kicked off by both houses of Congress. And not only does Congress have to establish the office by law first, but then, of course, it has a role. Different aspects of it parts of it have a role in even signing off on who the president picks to fill it. So Senate consent, or Congress could, of course, say the president alone or a department head can fill an office if it's inferior. But the by law requirement was really obviously essential, because until Congress acted and established departments or commissions or appropriated money, there was no executive branch, there was no government for the president to oversee or run. And so it actually was really foundational to our understanding. And is that Stanford Study of mine from several years ago that Justice Thomas and Gorsuch talked about in the Lucia versus Securities and Exchange Commission, finding unconstitutional the structure of administrative law judges in agencies, also comes up in Justice Thomas's concurrence, along with even more foundational documents like Thomas Paine's Common Sense, and this understanding that we really did not want just one person, here the president, his or her attorney general, or anybody, able to just create new federal positions and fill them because of all the power that's inherent in that exercise of authority. And so now, here 200 some years later, we have a district court judge saying, I don't think the statutory provisions cited here get the special counsel regulations across the line. And because she has applied that decision in a way that is resulting in the dismissal of this indictment in this closely watched case, it almost certainly is going to force the hand of the special counsel's office to appeal that decision to get to the 11th Circuit. And we're going to start seeing more people have to actually figure out and rule on and think about, what does it mean to establish an office by law? How specific does it have to be? How general can it be? And this is really not an issue that courts have weighed in on very much at all over the years, partly because litigants just haven't brought these kinds of cases. But it's actually quite important. Well, first, obviously, because the special counsel's office is exercising a lot of authority, but also because there are a number of offices within the executive branch. Although I think, if one were to look at the statutes closely, we'd see that here the special counsel provisions require a lot more of inferences and generalities than we see in the run-of-the-mill case of statutes establishing positions in the executive branch. So it might be that from a constitutional or statutory standpoint, one could argue that Judge Canon's opinion, or if it's affirmed on appeal, or whoever, is relatively narrow, in the sense that this particular opinion, I think, is written in a way where it really just applies to the special counsel office. On the other hand, it's hugely significant because the special counsel power has been used to open up many of these investigations that are raising some of the most thorny, controversial, contested political issues of our time. And it's that second point that might be the reason why Justice Thomas, writing separately here, and litigants are willing to entertain these arguments when they haven't really come up in litigation much before, because the special counsel office is just raising all kinds of questions about how does an executive branch essentially investigate itself? How does this unusual position of special counsel, where people float into these positions to run one investigation like Rob Hur or Jack Smith, really supervise and investigate the president himself, or here a former president? And are we comfortable with the lines of authority there? And at the end of the day, how is that office accountable back to the American public? Is it accountable in a way that we feel comfortable about? And, if special counsels were to come up even more frequently, would that be a kind of raw investigative power that we're concerned about in our system, which is supposed to involve limited government?
Okay, so given what you said about how controversial some of these decisions are, lots of people online are already attacking Judge Canon, talking about the decision as a miscarriage of justice. Who do you recommend people turn to besides you on Twitter and on TV? Who should we look for to find sober analysis of these issues?
Well, Jace, I think that days like today and questions like these provide a fantastic opportunity for listeners here and for students of government and the law and justice to open up a constitution. And just first, I really do think it's hard to even understand and bring any kind of a sober-minded view to any of these questions unless folks understand the constitutional provision that's being discussed. So I recommend skimming through, reading Article 2, at least Section 2 of it. And I recommend then, I suppose on this, it's also helpful to understand or have read the decision that one is criticizing or analyzing. And so maybe skimming through or at least looking at the introduction of Judge Cannon's opinion, perhaps looking at Justice Thomas's concurring opinion. But it really just, and these issues are not going to be able to be conclusively decided in an instant. And I think that anybody who's claiming either to 100% be sure that the decision today is right or the decision today is wrong, maybe hasn't reflected on the historical nature of the question and some of the broad lines that the Constitution gives to us. And while I am definitely a formalist and a believer in the text of the Constitution, so I do think a lot of the answers lie here in this document and needs to be followed, the document doesn't, by its very nature, can't always give a lot of details and tell us precisely how it's supposed to be applied to modern circumstances. So we can't oversimplistically say that we know for sure without doing any study, without doing any research, without reading any history, what by law, what the law has to look like to establish the office. So I think the best we can do today is understand the contours of the issue. Where's the debate coming from? Why is it important? And then if one actually really cares, as the case gets further litigated, read the statutes in Title 28 of the U.S. Code that the special counsel is relying on for its authority. And, we're all smart readers and interpreters of language, and we should really be investigating these questions for ourselves. And at the end of the day, I think be glad that there are a lot of actors in our system of government and outside players who have the freedom and the ability to be able to study these issues and bring different thoughts and perspectives to bear. So we're not just stuck with hearing one viewpoint or stuck with relying on what somebody from the bully pulpit or with a big public megaphone says. We can all look at the documents and study them for ourselves.
Well, thank you very much. We'll link to those documents in the show notes, and thank you for joining us today.
All right. Thank you, Jace. Have a great afternoon. Great to be with you.